Okay, Alhamdulillah. Alhamdulillahi Rabbil Alameen. Wassalatu wassalamu ala ashrafil anbiya'i wal mursalin. Nabiyina Muhammadin wa ala alihi wa sahbihi ajma'in. Amma ba'du. Fassalamu alaikum warahmatullahi wabarakatuh. Okay, good day everyone. So this is our third meeting. Inshallah, another session for a fruitful discussion on Muslim law, on inheritance and succession. So just a quick recap of what we have discussed last meeting. So we have discussed about the pre-Islamic and classical practices of the Arabs on succession and inheritance. So we know all the unjust practices that were repealed or that were removed, that were stopped after the advent of Islam and after the revelation of the verses on Islamic law and inheritance. So among such practices in the Jahiliyyah period, in the pre-Islamic practices of Arabs, is the is that women and children, those who are weak, basically don't inherit anything from the descendant, from the head of the family. So if the head of the family died, they the women and the children and the weak cannot inherit anything from it, and only those who are strong, who can defend the family, who can defend the clan, can inherit. This is also the main reason for this is that so that they can protect the wealth, and also this is a excuse me. This is a practice so that the strong will inherit the wealth of those who die, and basically women were considered as part of the wealth, so they are among the wealth that is being inherited by the heirs or the inheritor of the descendant. So there were events that prompted the revelation of the verses on the law of inheritance, particularly the one of the Sahabiyat went to the Prophet Muhammad Sallallahu Alaihi Wasallam regarding the inheritance. After the Battle of Uhud, her husband died, and the uncle or the brother of the descendant want to get the wealth that was left behind. Can anyone remember who's that Sahaba and Sahabiya? Who's the Sahaba that died?
Aus bin Tabit, Prof.
Then who's the Sahabiya? The one who went to the Prophet to ask?
The wife.
Yes, the wife.
Yes, sir. The name is... Maghahanap po.
It's okay.
Ansari is the widow. Tama po ba? Ansari po ba yung pangalan niya, Prof? Or ibig sabihin po ng Ansari is widow?
Hindi, ang Ansari, ano yan, sila yung mga Ansar. They are from Medina. No?
Okay.
So anyone who can remember? Alam ko may nag-mention no, nung hadith, nakadalong mention ata yung
Opo.
uh, reporters.
Tabit Ibn Case. Tama po ba yun? The daughters of Tabit Ibn Qais, Qays.
Sheikh Kadja?
Ewa.
اسمها Kadja, صح؟
Jamila? The name, sir? Jamila po?
Mm-hmm. So, a little information like this, information like this. Hope that you can take notes of that. No? Para at least we know the asbabun nuzul, the cause of revelation, and who are involved in that revelation of those verses. Kasi ang verses lang naman na importante sa inheritance, no? Particularly, no, very important sa is yung two verses, no? Verse 11 and 12 ba? Then 175,
176.
176.
Suratul Nisa.
Sa Suratun Nisa, no? So verse 11 and 12, then verse 176. Okay. So, Alhamdulillah. No? So, after that, after the revelation of that verse, no, that Quranic verse, the rights of each member, no, or the ears, has been made clear. So, looking at that, at those verses, we will know that there are primary ears that will never be excluded from the estate of the dissident. Estate of the dissident. So those primary ears, no, first is children, no, son and daughter. Daughter has a specific share, and the son, when inheriting together with the daughter, he gets twice the share of one daughter, no, one female. So lidhakari mithlu hadhil unthayain. So actually that principle is applicable almost all the time, no? Yung male ears shall have twice the share of a female. Then another are the parents. So they are always among the ears that will not be excluded. So the father and the mother. So if the father inherits without any son, without any male descendants, so he inherits as a asaba, no, as a asabul mirath, and also the mother, so has a specific share, 1/6, 1/3 if there are no other descendants, no. Then next are the spouses, no, spouse, no. So if husband or wife, they always have a share in the inheritance. So lima yon, no, spouse, So either husband and wife, the parents, mother, father, then yung daughter and son. So yan ang palaging nakaka-inherit at hindi kailanman na-exclude. So after them, or if tsaka lang makaka-inherit yung iba ng mga collaterals. What we mean by collaterals is yung mga brother and sister ng dissident, no? Or at mga anak nila, mga niece and nephew, o particularly nephew ng dissident. So yan ang mga maka-inherit lang sila after, maka-inherit lang sila kung wala yung nasasabi natin na 5. Usually nauubos na yung mga portion, shares ng years pag nandyan in existence yung 5. Kasi yung son always residuary. So anything that is left, no, will go to him kung wala yung daughter, no. But kung nandun na naman ang daughter, no, ganun din. Lahat ng residue sa kanila, sa daughter and son, but ang hatian nila ay 2:1. So yan ang kaya sabi natin, pag wala lang sila, tsaka lang makaka-inherit yung iba. Then another that we have discussed, no, yung mga yung verses, no, yung 11 to 12 at saka yung 176 ng Surah An-Nisa. So alhamdulillah, thank you very much doon sa nyo, no, sa discussion natin, sa report nyo. We have learned a lot. Now, we will proceed and have a report, a discussion on the share of women under Islamic law on inheritance, the sources and significance of the law on succession in Islam, and the Code of Muslim Personal Laws of the Philippines, its history and application. So who will be the one to start? Who is willing to go first?
Sure.
Okay. Oh, si Sir. Okay, Sir Dimaro. Alhamdulillah. So if you have a presentation, or hopefully meron kayong presentation materials, you may use the screen share function.
Yes po.
By the way, don't forget to upload all of your press match presentation materials dun sa Google Drive link na binigay natin, so that anyone who wants to review, they're able to access it. Okay? Parang dalawa pa lang nakakita kong press mat doon, presentation materials.
Nakikita na po, sir.
Yes. Pwede mong i-max, use the yung slideshow. I-start mo na yan.
Okay, alhamdulillah. Assalamualaikum. Greetings of peace and prosperity to Sir Professor Lokman and to my dear classmates. Again, good afternoon. Now, thank you so much for this opportunity to present first in this session. Now, the first question I prepared is first, are women in Islam considered legal heir? And if so, then the follow-up question, what are their share in case of succession? Number 2 question, what are the Quranic verses? And number 3 question, how did they implement in Philippines? Now, the share of women in Islamic law on inheritance. First, in Islam, women are entitled the right of inheritance, though generally, Islam allocates women half the share of inheritance available to men if they inherit from the same father. For example, where the decedent has both male and female children, a son's share is double that of a daughter's. Number two, there are other circumstances where women might receive equal shares to men. For example, the share of the mother and father of a decedent who leaves children behind. Also, the share of a brother who shares the same mother is equal to the share of a sister who shares the same mother as to the shares of their descendants. And number three or third, sometimes women get double the share of that of men. For example, if there are only parents and husband, then husband will receive half, then father will get 1/6 and mother will get 2/6, which is bigger or larger than the father and the husband of the deceased. This is according to Ibn Abbas' interpretation of verses 11 and 12 of Suratul Nisa, An-Nisa, or Surah An-Nisa. Also, I prepared a presentation to the different types of heirs. Heirs referred to as the primary heirs and always entitled to a share of the inheritance. They are never totally excluded, of course, because they are the primary heirs that consist of the spouse, the husband and the wife, both parents, the father and the mother, the son and the daughter. All remaining heirs can be in the presence of the heirs, but under the certain circumstances, other heirs can also inherit as residuaries, namely the father, the paternal grandfather, daughter, the agnatic granddaughter, full sister, consanguine sister, and mother. Those who inherit are usually categorized in three groups. First, the quota heirs or dawu al-fara'ad. This group includes 4 males and 8 females. The male quota heirs are the husband, father, paternal grandfather, and maternal brother. The female's quota heirs are the wife, daughter, granddaughter, mother, grandmother, full sister, paternal sister, and maternal sister. However, there are scenarios that could move the daughter, granddaughter, father, grandfather, the full siblings, or full brother and sister and paternal siblings to the second group or asaba, or this what we call the residuaries. Usually, a combination of male and sometimes a female relatives that inherit as residuaries after the shares of the quota heirs is distributed. And the number three types of heirs are the extended family members or da'u al-arham. This includes any blood relative who is not a quota heir or asaba residuary. Examples are those include the maternal grandfather, the aunts, nieces, and the female cousins. Now, these are the sources of the law on succession in Islam. First is the verse number 11 of the Suratul Nisa. It was interpreted by Ahmed Ali as for the children. God decrees that the share of the male is equivalent to that of 2 females. If they consist of women only, and of them more than 2, they will get 2/3 of the inheritance. But in case there is one, then she will inherit 1/2. The parents will each inherit 1/6 of the estate if it happens the deceased has left a child. But if he has left no children and his parents are his heirs, then the mother will inherit 1/3. But if he has left brothers, then the mother will inherit 1/6 after payment of legacies and debts. Of parents and children, you do not know who are more useful to you, then these are the decrees of God who knows all and is wise. So in this verse, my classmates, it shows that before the distribution of, it shows first that actually the female or women are really given equal shares to the against men of the member of the family. Also, before the distribution of all the shares of the sharers or the legal heirs, then it must be first deduct muna yung mga legacies and debts, kung ano yung mga utang at saka kung ano ang dapat na bayaran doon sa mga naiwang estate ng namatay. Okay. Also, verse 12, according also to the interpretation of Ahmed Ali, your share in the property, the wives leave behind is half if they die without an issue. But in case they have left children, then your share is 1/4 after the payment of legacies and debts, and your wife shall inherit 1/4 of what you leave at death if you die childless. If not, then she will get 1/8 of what you leave behind after payment of legacies and debts. So if you can observe, classmates, that in every verse, it always says that before it will distribute it, or before it will distribute to the legal heirs, that there must be the payment of legacies and debts must be conducted first before pa natin ibigay yung share ng mga heirs natin. Also, a verse 176 of the same surah, as interpreted by Ahmed Ali, they ask you for judgment about akalalaha, a man who dies childless. Ito yung deceased na namatay, na wala siyang naiwang mga anak. It say that God has given a decision in the matter of inheritance. If a man dies and leaves no child behind but have a sister, she will get a half of what he owned, as he would have done the whole of what she possessed if she had died a childless person. In East, he has 2 sisters, then they will get 2/3 of the heritage. But if he has both brothers and sisters, then the male will inherit a share equal to that of 2 females. God makes this manifest to you, lest you wander astray, for God has knowledge of everything. So meaning, classmates, that the 3 verses mentioned, it really shows that the women were really given the equal rights with the men in relation or in case of the inheritance. Now, this is the the third question is how did the implement in the Philippines, though, the history of the PD 10823 or the Muslim Code of Personal Laws. It was on 1971, the Muslim delegates in 1971 in the Constitutional Convention. They influenced the government during the time of the former President Ferdinand Marcos Sr. for the formulation and eventual ratification of the Code of Muslim Personal Laws. And on August 1973, the President Marcos issued a Memorandum Order 370 to create a research staff to draft the proposed Code of Philippine Muslim Laws. And on following year, or 1974, an Executive Order 442, they designated, or the President designated Cesar Mahul of the Institute of Islamic Studies of the University of the Philippines to lead the Presidential Commission in reviewing the draft code with 11 members. And on 1975, August, the President Marcos received the group's final report on draft code, and on the following next 2 years, February 1977, President Marcos signed the Presidential Decree 1083 or PD 1083. And on 1983, the first special Sharia bar exam conducted, and on 1985, that's the time the Sharia courts opened, and that the Code of Muslim Personal Laws became operational 8 years after its promulgation, right after the Code of Muslim Personal Laws signed by President Marcos. That was on 1977. And the application of the Code of Muslim Personal Laws of the Philippines is that is actually they considered as part of the law of the land that recognizes the legal system of the Muslims in the Philippines and provides effective administration and enforcement of Muslim personal laws among Muslims. So thank you, and Alhamdulillah, these are my reference that I used to this report. Thank you.
Thank you very much. Shukran jazilan. No? Thank you very much dun sa napakagandang report ni Sir Dimaro, and this really helps you to make it more effective, no? Lalo na sa pagre-review and pag-intindi, no? You have to create craft questions, no? So ang naging missing na lang doon ay yung yung 2 highlights mo, yung 2 reflections mo, then yung one very important point.
Yes. Okay, sorry. I will.
Yes, that's fine. At least there's a really big improvement. So Sir Dimaro, can we go back to your slides, and siguro baka makalimutan kasi later. Let's start sa very beginning. I want kasi we will be discussing then yung mga terms of reference, yung mga terms, no? Yung definition of terms sa next session natin, but siguro dito pa lang umpisa na natin. So dito sa napakaganda ng share of women, napakaganda ng pag-discuss mo rito. And yung third case, no? Anyway, we will discuss that. That's actually a special case din, yun yung Umariyatan, no? 2 case Umariyatain. So inshallah, we will come to that, and we will see actually ano bang applicable din sa Philippines. So dito kasi the father gets less actually than the mother. So yan ay special case yan, no? And meron ding decision dyan si Caliph Umar, no? Amirul Mu'minin Umar bin Khattab radiyallahu anhu. Sa next slide po, sir. So dito, yung yung ginagamit natin ng mga terminology. Please take note, no? Ito ay paulit-ulit. Lalo na sa mga nakikinig ngayon, no? Take note nyo. So, ito, the whole fara'id, no? Fara'id ang gitawag sa ang sa hadith, no? Ang ginagamit ashabul fara'id o ashabul faridah, no? Ashabul fara'id. Fara'id yan, no? Fara'id. Then yung asaba, always take note that din yan, no? Yung asaba, sila ay sometimes tinatawag silang ashabul mirath. Ashabul mirath, ashabul fara'id, ashabul mirath. So asaba, residuaries. So they are the one who receive what's left, no? Sila yung mga mag-receive ng kung anong natitira. Then yung dhawul arham. Dhawul arham, they are the ito yung mga relatives na they will not be able to inherit unless wala yung mga usual na mag-inherit. Wala yung ashabul fara'id o yung dhawul fara'id at saka yung mga asaba. Next slide. Yung kanina, yung sa last slide, previous slide, yung kalala, no? Kalala yan, kalala. Ang kalala, when you say kalala, siya yung tao na walang ascendant at walang descendant. Walang buhay na ascendant, wala siyang mga magulang at wala rin siyang mga anak. No? So, Diyan din nagkakaroon ng special inheritance yung mga siblings, yung mga collateral, yung mga kapatid ng namatay. So when you say kalala, no, kalala, walang ascendant, walang descendant. So thank you very much. No, you may stop. Let me just stop the sharing. So any questions or clarification dun sa presentation ni Sir Dimaro, sulat nyo muna sa chat, no? Then later we will get back to it at siguradong sasagutin ni Sir Dimaro yung mga tanong niya. Okay, so sinong next na magpa-present? Anyone who wants to volunteer? Ready na?
Ako, sir,
Ayun.
pwede na po.
Okay, sure. So you
Share
may
call.
use the screen share function. Yung mga terminology, no, as I have said, it's very important because we will always encounter them. So you need to take note of that and have the correct or correct understanding of those terminologies. Please proceed, Ma'am Saber.
Wait lang. Okay na po, sir.
Yes, we can see it now.
Okay, sir.
Usman, no? Usman bin Usman Imam.
Lagi.
It's okay.
Sorry po, sir. Hindi ko pa rin po
Iba.
nababago. Okay.
Okay.
Opo.
Proceed.
Assalamualaikum warahmatullahi wabarakatuh, Prof, mga classmates. So this is the second report that we have. So Islamic law of inheritance and succession. Part 2, the share of women under Islamic law on inheritance, the sources and significance of the law on succession in Islam, the Code of Muslim Personal Laws of the Philippines, PD 1083, history and application. Okay, I have 3 questions. So on topic assigned, my number 1 question, what are the share of women under Islamic law and its basis? How law on inheritance and succession becomes effective or enforceable in a country? Can Muslim law on inheritance and succession stand absence of PD 83? So these are the questions that I will be answering with my presentation. Okay, so I made a table here. So to answer my question, what are the share of women under Islamic law and its basis? On the first column, the decedent. So the father, husband, son, or daughter, uterine brother or sister. So on the second column, that is the share of the women. For example, the father died, leaving daughter. The daughter survived with male sibling. So ibig sabihin may kapatid siya, yung babae may may kapatid siya na lalaki na nag-survive. So the women will get 1 portion, 1 share to the daughter and 2 share for the son. So what is my basis for that? That is under Surah Al-Nisa verse 11 and under Article 1117 of PD 1083. So again, father died. Yung una, may kasamang kapatid na lalaki. Yung second type naman, yung kapatid, daughter, survive without male sibling. So siya lang, wala siyang kapatid na lalaki. So she will get 1/2 of the estate. And 2/3 of the estate if 2 or more females survive. So again, it's Surah Al-Nisa 4:11 in Article 1 117 of PD 1083. That's the basis. And for example, the decedent is the husband. Yung husband naman po yung namatay. Ano naman po ang makukuha ng woman heirs? The wife. Wife survive without children. Siya lang, wala silang anak. So she will get 1/4 of the estate. And my basis is Surah An-Nisa 12. Article 112 PD 1083 of Article 112 of PD 1083. That's my basis. And then why survive with children? So ibig sabihin yung asawa may anak siya, namatay yung tatay, so yung asawang babae, sir, 1 second lang po. Hello sir, sorry po
It's fine. It's okay.
Pumatok yung mother-in-law ko, binibigyan ako ng pagkain. Okay.
Mashallah.
So, wife survive with children. So the wife, because I'm only talking about the wife, she will get 1/8 of the estate. And my basis is Surah Al-Nisa, verses 12, and Article 112 of PD 1083. Now, the decedent is the son or the daughter. What will the mother gets? So the mother survive with the grandchildren. It means yung son or daughter na namatay, meron siyang mga anak. So yung nanay niya, the mother will get 1/3 of the estate. I did not discuss the grandchildren because it's discussed on the first portion. And the basis Surah Al-Nisa 11, Article 114 of PD 1083. And mother survive plus siblings of the deceased. So the siblings of the deceased are the collaterals already. They are not the compulsory heirs, as we say, or the wul al-faraid. So the mother will get 1/6 of estate after fulfillment of bequest and death. So my basis here is Surah Al-Nisa 11 and Article 114 of PD 1083. Okay, I discuss here the uterine brother and sister survived by female. Wait lang sir, hindi ko makita. Paano ba ito itataas? Okay, hindi ko makita yung babang portion. Survive only by female siblings.
Or a male sibling on the mother's side.
Yeah,
And
or male.
nakikita
yes.
namin.
Okay, so ako hindi ko nakikita na nakokoveran siya. Sibling, sir, sorry, hindi ko talaga makita yung babang portion. Siblings or that more than
On
after.
on mother's side.
Yes.
Then dun sa third line, 1/6 for each siblings or 1/3 of estate if more than one after fulfillment of bequest and death without harm to the heir.
Yes, sir. So the basis is Surah Al-Nisa again, verse 12 and PD 121 of PD 1083. Again, I only discuss here the share of the women.
Mhm.
Okay, and my number two, to answer my number 2 question, the law on inheritance and succession becomes effective or enforceable in a country under the following condition. I read other sources, sir. So according to Abu Aisha lecture, the canonization and codification of Islamic law of inheritance and succession is through Quranic revelation and Sunnah. Whereas the groundbreaking works embarked upon the early Islamic scholars and juries, and the next generation had uniquely venerated the Islamic process of inheritance and succession as a means to create rooms for legal transfer of wealth, property, and lineage from one generation to another. While in the Philippines, the enactment of PD 1083, otherwise known as the Code of Muslim Souls of the Philippines, has sealed the Muslim law on inheritance and succession. Hence, Muslim law on inheritance and succession becomes effective and enforceable in a country by this is just my opinion, sir. in a country by enacting a law adopting the Quranic verses and the Sunnah. Although I've read after that some cases where the Supreme Court said that even before the time of the Moro, time immemorial, the law of Muslim law on inheritance and succession is already been used. And to discuss about the PD 1083, otherwise known as the Code of Muslim Laws of the Philippines, I have the date here and the antecedent. February 4, 1977, President Ferdinand Marcos signed PD 1083. In May 16, 1977, the code was published in Official Gazette. Although at the time, 1973 Constitution, the publication in Official Gazette is not yet a mandatory requirement. In 1982, the Ministry of Muslim Affairs established the Philippine Sharia Institute to provide Sharia's legal education for prospective Sharia bar examinees, law practitioners, and judges. In 1983, first Sharia bar examination was conducted. 9 successful candidates was appointed as Sharia judges and pursued study in Egypt. And in 1985, the first Sharia court was opened. The CMPL becomes operational 8 years after its promulgation. CMPL recognized the legal system of Muslims in the Philippines as part of the law of the land and codifies Muslim personal laws and provides for the administration and enforcement of the code through the establishment of Sharia courts. Number 3, yes, to my question, yes, Muslim law on inheritance and succession stand. Absence of PD 1083 for the following reason. Number 1, the primary source, the Holy Quran, the Sunnah. Sunnah al-Nisa specifically verses 7 to 14 and 176 provides the partition of decedent estate to its heirs. Number 2, Sunnah of the Prophet Muhammad sallallahu alaihi wasallam. Number 3, I just mentioned here because I read the lecture of Abu Aisha in Nigerian Supreme Court decision, where the court says Muslim law is universal law, which is applicable and enforceable upon all Muslims anywhere in the world. However, there is need to prove it in court. So other secondary source, when Muslim in any part of the world insists in any court of law on Islamic law as his or personal law, is more a matter of law and right than religious consideration. Of course, these 3 and 4, it needs to be proved in court if the Muslim will have to go to court. The sources and significance of the law on succession in Islam. Primary sources, the Holy Quran. Number 2, Sunnah of Prophet Muhammad sallallahu alaihi wasallam. Secondary sources, qiyas, individualistic analogical deduction, ijma, consensus of scholars, ijtihad, judicial exertion, al-urb or customs, istisan, juristic preference. 6, istisla or maslaha, consideration of public interest. Istisla, legal presumption of continuance.
Istishab.
Istishab po, opo. Okay, and I just discussed here the case of Khairi Saidan versus Fatima Khalil Mohsin. I just feel it's worth discussing it to the class. This is again a Nigerian case. The petitioner here is the Lebanese mother who demanded that the estate of late son Yusuf be devolved according to Muslim law. So namatay yung anak niya, Lebanese yung Lebanese sila, pero namatay yung anak niya sa Nigeria. Sabi ng nanay niya dapat yung estate niya hatiin according to Islamic law. Sabi naman ng widow ay hindi po pwede. Ayaw. So magkalaban sila. The court in granting in favor of the mother states, the evidence presented proves uncontradicted evidence that the decedent is a Muslim. So here sa court, it was proven that that the dissident is a Muslim. For a Muslim in any part of the world to insist in any court of law on Islamic law as his or her personal law is more a matter of right and religious consideration. With the above pronouncement, the court further state that the Muslim law applies to all Muslims who lives in the north or south and non-establishment of Sharia court in the south, because at that time only the north has the Sharia court while the south do not have the Sharia court, is not seen as impediment for anyone to demand the devolvement of his or her estate according to Islamic law. So ang point dito is kahit walang Sharia, parang ang pinopoint ko rito, sir, I'm trying to point is kahit nasaan tayo, may Sharia court o wala, basta sinabi natin Muslim tayo, so I want my property to be divided according to my faith, my religion as a Muslim. Hence, Muslim law is universal, which is applicable and enforceable upon all Muslims anywhere in the world. And number 2, the case of Animas Shaun and Oyeneyin. Again, Nigerian case. In this case, even though dissident is a Muslim, Nigerian Supreme Court did not rule on the basis of Islamic law but of customary law. Here, dissident died intestate without a will. The court say that Muslim must pronounce their estate as devolvable according to Islamic law while alive through Islamic will or wasiya, or content with the consequence of dying intestate where his estate was devolved according to the native law and customary customs of the community unless proven otherwise. So here, namatay po yung dissident, wala po siyang will. Sabi po ng Supreme Court ay hindi po pwedeng, kahit Muslim ka, hindi mag-a-apply ang Muslim. Dapat, nung nabubuhay ka pa, dapat may will ka, may wasiya ka para ma-divide yung estate mo according to Islamic law. So medyo magkaiba po yung, although magkaiba yung issue ng dalawa, pero iba po yung pronouncement ng Supreme Court dito. So sa kabila, dito po sa pangalawa, kailangan po natin ng wasiya, ng will, para po ma-i-apply po yon. Okay, so number 2, personal reflection or highlights. My personal reflection on the given topic is that there is no law that is greater than the Holy Quran on the point of view of a Muslim believer. However, for non-Muslim, there is a need for enabling law to accept it as part of the law of the land. My second reflection is PD 1083 is subject to amend in order to adapt to the change of time. So that's what I have in mind. So kasi it's a law. So subject to amendment po ba to? Yun po ang tanong ko. And one very important point, Surah Al-Nisa number 1, O mankind, be dutiful to your Lord who created you from a single person, Adam, and from him, Adam, he created his wife, Hawa, Eve, and from them both he created many men and women, and fear Allah through whom you demand your mutual rights, and do not cut the relations of the wombs, kinship. Surely Allah is ever an all-watcher over you. Thank you very much po. Yun report ko po, sir.
Okay. Thank you very much. No? Napaka ganda ng report ni Ma'am Saber, and particularly yung table. This will be very helpful to use dun sa table ng yung years, yung inheritance, yung share. No? Kasama talaga sa ating course is yung pagdi-discuss, kukompute ng magiging portion or shares ng bawat years. So later on, talagang makita natin, mag-compute tayo, we will be using dapat tama yung computation natin. So you should know the right share, applicable share, and at the same time kung sila ba excluded or not. So dun naman sa patungkol sa Supreme Court decision sa Nigeria, very maganda, napakaganda na i-cite yan.
Opo.
And at the same time, this will give us an idea, no, as Muslims, para mas sigurado, no? Although we can prove it in court as a fact na tayo ay Muslim and we want it to be everything. Ang personal law natin ay according to Islamic law, no? Kasi ang personal law naman kasi nadadala ng tao yan kahit saan man siya sa mundo. No? Kahit basta yan, pag sinabing personal law, anywhere in the world, no, you bring it with you. So for us, no, for us Muslims, we can see here the importance din ng wasiyah. And this has been emphasized, no, and stressed in the Quran many times. And there, at one time, wasiyah has become a wajib, obligatory, no, for a Muslim. So ngayon, naging sunnah muakkada na lang, sunnah muakkada siya with the revelation of the laws on inheritance. No, but it's still a good practice for each and every one of us to write a will. We don't know when we will die, and at the same time, this will give us a reminder, always a reminder that this life is really temporary, and it will make us always prepare, and kung may mga importante na kailangan sabihin sa will, kailangan masabi natin. This will also become, pwede rin maging parang goal, no, reminder sa atin na as Muslims, we need to prepare for our death. Hindi naman tayo magtatagal dito sa mundo, no? Ilang taon na lang ba natitira sa atin. So alhamdulillah, this is actually a very good practice, lalo na kung ikaw ay nasa non-Muslim o majority country. So sa Pilipinas, particularly, hindi tayo Muslim country, minority tayo. So marami talaga sa mga ang natataman dito palagi ay yung mga revert to Islam, mga balik Islam, no? So kung wala silang will, hindi nila alam ang gagawin sa kanilang bangkay pag namatay sila. Minsan ililibing sila na not in Islamic way. Maaari pang ano ba yung tinatawag doon? Ma-cremate pa sila. So Allahu Akbar. This is no. So kailangan palagi tayo may will. Even no, lahat tayo as Muslims need to be prepared. So maganda, no? Maganda tong report. Thank you very much. Doon naman sa reflection mo. Doon sa second reflection, no, amendment, no. So ang amendment actually na by sino ba tong I'm not sure sino tong may ayan. Yung sa amendment naman, actually there are many attempts that were done to amend PD 1083, no, until now. At this is actually one of the fears of Muslims in the Philippines, kasi when you open it for amendment, baka lahat mawala at baka yung mga rights na in-enjoy natin ngayon at saka yung laws na that protect us ay baka mawala. And isang ginawa ngayon just recently ng mga ng Senate, no, particularly si Senador Risa Ontiveros, no, with the passage of law of yung anti-child marriage law, no. Doon actually it really amended a part of PD 1083, no. Naapektuhan niya to dahil sa under PD 1083, as long ang tinitingnan dito is yung yung age of puberty. So there's no specific number in the age of puberty. So as long as you are in the right nandun ka sa bulug, yung sinasabi natin na akil balig, you are of sound mind and age, no, nasa majority age ka, you are allowed to get married, to be married and to get married, no, to marry. So ito ay has been effectively amended with the passage of the yung batas na anti-child marriage law. So kasi dito kino-consider nila na dapat ang pwede lang magpakasal ay 18 years and above, if I'm not mistaken, yes, 18 years and above lang. So ibig sabihin yung mga below that, kahit nasa tamang pag-iisip ka na, nasa tamang edad, you are able to discern what is right and wrong. Ngayon, ang bilis mag-mature ng mga bata, no? Hindi na sila bata actually. So, ito ay pinigilan. So, ang malaking naapektuhan nito ay yung mga may mga practices, no? At saka yung mga Muslims. Actually, this law was made for Muslims. Kasi ang mga non-Muslims naman, they don't really care about marriage. They can live together. They can cohabitate, man and woman, girlfriend, boyfriend. They can cohabitate. They can do everything what they want, no? Without marriage. So ang target talaga ng batas na to ay ang at kabataang mga Muslim at siguro mga IPs na rin. So dito, makita natin na ipagbabawal nila yung what will really protect women, no? Lalo na yung mga young ladies, young women. Hindi naman kasi sila children, they are young ladies. Pwedeng young ladies and young women. So ang nagiging problema dyan, so parang gusto nila encourage yung cohabitation without marriage, no? So yan ang gusto nilang pilitin ng mga Muslims na maging ganon. Kasi ang mga sinasite nilang reason daw, marami daw single mother, marami daw mga kabataang babae na deprive of their opportunity for education, for employment, etc. So the question really is, will this really answer, or will this really solve itong mga sinasite nilang problema? Ang mga babae ngayon, maraming nabubuntis, walang kasal, no? So wala silang right. When you are mas vulnerable sila kung hindi kasal, no? Mas vulnerable sila. So sa Islam, MPD 1083, it recognizes that when you are at the age of puberty, you are of sound mind, and you are in the age of discernment, you are in age of majority, you can start a family life. You can get married. So ito yung isang problema ngayon na kinakaharap kasi malaking yung violation nito is a criminal act. So magiging pag criminal, makukulong ka, malaki talaga. Lahat ng involved din, no? Yung nagkasal, nag-facilitate, etc. Lahat sila involved dun sa magiging kaso at napakabigat ng parusa. So ito ay isang mga problema na current na kinakaharap natin ng mga Muslim. Kasi siguro hindi sa ibang mga but yung mga Muslim tribes, no, ethno-linguistic tribes sa Philippines, they have this practice na kasi pag may mga dalaga at binata nagkagustuhan sila at sila ay nagtanan, no? Waliyadu billah, nagtanan sila. So ang isang solusyon dito ay ikakasal sila. Instead na magiging redo kasi yan yung family feud, no? Magkokos yan ng redo. So unless hindi ma-resolve yon, usually ang solution that ay ikakasal na lang sila, yung babae at lalaki, kakasal na lang sila. So pag hindi ito naikasal ngayon, dahil bawal na magkasal, kasi pag kinasal mo sila, makukulong ka, may malaking fines at saka yung penalties, magiging redo yan, magiging redo. So isang magiging kaguluhan na naman, no? Particularly sa mga Maranao, no? Ganyan, mahirap yung situation na ganyan. So alhamdulillah, thank you very much dito sa yung report, no? At kung may mga tanong kayo sa report ni Ma'am Saber, kindly write it in the chat box. Nag-adhan na for Maghrib, so we will take a break. Ang ating break ay we will come back after 20 minutes, no? 20 minutes or 25 minutes. So magsulat lang ng inyong mga tanong sa chat box kung may hindi tayo na-discuss. Actually, dun sa sources, no? Anyway, we'll come back to that. Yung kagandahan, no? I will present to you. Ano naman yung peculiar and yung siguro advantage ng PD 1083 compared sa ibang mga codified laws, Muslim laws, no? Sa mga hindi majority na Muslim country. So, see you later. Let's take a break. Assalamualaikum. Okay. Okay, alhamdulillah. Let us resume. Nakabalik na ba lahat? So ang next na magre-report si Sheikh King Mulan. Nandito na ba? Parang nag-request si Sheikh. Aywa, tafadhal ya Sheikhana.
Okay. Iusin ko lang yung power ko.
Ano, kaya na ba? Yung power presentation? Pwedeng gamitin yung ano, share screen.
Hindi ma-share yung slides ko.
Hindi ma-share?
So,
Upload mo sa ano,
kino-convert
sa
ko siya.
pwede mong
Pwedeng mauna na lang yung iba.
sige, sige. So sinong gustong mauna? Si walang gusto mag-volunteer? Voluntold na lang daw, voluntold. Tinanggap na yan na bagong word, no? Voluntold. Sa pilitan na i-volunteer ka. Si ano na lang. Ito si Bukhari, Yasin.
Volunteer.
Voluntold. Okay. Proceed.
Share screen ko lang. Nakikita na po sir.
Yes, yes.
Assalamualaikum everyone. May report. Personal plus and head. So, next slide. The share of women under Islamic law. Sunod mo at dito yung sorry. So, the Al-Quran. Mga ayat pa sa surat. So please refer to the case of Sa'd al-Rabi. After this verse, the verse of inheritance was revealed, which is Surah Ayah 11, which stated, Allah charges you in regard with your children son's share is equal to the share of 2 daughters po. So yung share po ng man is equal to 2 of daughters. Next slide. So, mga mention ko lang po dito is yung sharing po sa mga babae po, which is yung wife, daughter, tsaka po. So, sa wife po, yung sharing po niya kapag walang anak is 1/4 and 1/8 kapag may anak po. So, in addition po sa wife, so only one person inherits an 8 and is the wife, and if there is more than one wife, they split it. So maghahati-hati po sila. Marami pong asawa. Then next po, sa daughter, 1/2 kapag isa lang po siya, which is wala pong kapatid na babae o lalaki po. Only one. And 2/3 naman kapag 2 or more daughter present, the absence of brother. And in addition po, 2 granddaughters of the son alone without grandson po. Then sa mother naman po, mapupunta sa kanya is 1/6 kapag may anak po. Or if with 2 or more brothers or sisters. Then 1/3 naman po mapupunta sa brother kapag if wala pong anak. And so, kung tama po. If with only brothers or sisters po. Sa next slide po. So ito yung tanong ko, what is the ruling for illegitimate child? Is he, she has the right to inherit father po? So ang sagot po doon is no. Ang comment po, if she bears the children before 6 months, even after being legally married to him, he or she will be only attributed to his or mother po. And sabi po ng mga scholars sa mga Maliki, Hanafi, and Shafi'i, both illegitimate and imprecatory children cannot inherit to their father because it is assumed that as if they don't have a father po. So, hindi po talaga sila pwede inherit sa atin nila, considering na they raised without a father po. So next slide. Why women have only half the shares of the men? So, ang sagot po doon, base po sa surah Nisa ayat 34, the men protectors of the women because he has bestowed Allah some of them over others, and because they spare from their so the righteous women are obedient, guarding in the unseen that which orders them to guard by Allah, and those from whom you fear their ill conduct, then advise them, and forsake them in the bed, and finally strike them. Then if they obey you, they then do not seek against them away. Indeed, Allah is most high, most gracious. So, dito po, kung bakit mas taas ang share kumpara sa babae. Kasi yung kalalakihan po are providers po. And men are responsible for mahar, and men are responsible for shelter and living expenses po. While the female, she keeps all her wealth alone. She is not responsible for living expenses and shelter. She receives mahar alone unless she openly expresses to share her wealth po. How will you determine the gender of her credit? So, before the age of puberty, if it urinates through the male sex organs, it would be a male. If it urinates through the female organs, it would be a female. If it urinates through both the male and female organs, the organs through it passes first will govern the gender. And after reaches the age of puberty, it grows beard, it will be male. If if it becomes pregnant and menstruation, it would be a female. So next slide. The sources and significance of the law on succession. Under Muslim law, succession is a combination of four sources. The Holy Quran, Sunnah, practice of Prophet, Ijma, consensus of the learned men of the community or over the decision over a particular subject matter. Qiyas, deduction based on analogy, on what is right and just in accordance with good principles. Significance of the law on succession in Islam. It is obligatory according to the Quran and Sunnah. Quran 4, Ayah 11 and 11. Ayah 7 and 11. Next, the Prophet Muhammad, peace be upon him, said, learn the laws of inheritance and teach them to the people, for they are one half of the useful knowledge. The Prophet Muhammad, peace be upon him, said, give the fara'id to those who are entitled to receive it, and whatever is left is for the closest male relative. Al-Bukhari and Muslim. Next, verily Allah subhanahu wa ta'ala has given everyone who has a right his right. So there is no bequeathal for the person who inherits. Abu Dawud and other Sunan. So next slide po. The Code of Muslim Personal Laws of the Philippines, PD 10, History and Application. In 1973, Marcos established the research staff for the codification of the Muslim laws, headed by Michael Mastura, who would later be involved in drafting the post-Marcos 1957 Constitution, and is currently a member of the negotiating panel for the MIL. In 1974, the research staff submitted a draft code of Muslim personal laws that drew heavily on local adat or traditional customary law and practices, reflecting practice in Muslim areas. A presidential commission established to review the draft code submitted a revised version in 1975 that reinforced constitutional supremacy and was aligned more closely with the practice in the Middle East. So on February 4, 1977, the Presidential Decree 1083 was signed into law. Constitutionally, the decree drew on Article 15, Section 11 of the 1973 Constitution. The state shall consider the customs, traditions, beliefs, and interests of national cultural communities, the formulation and implementation of state policies per Article 2. So the Code of Muslim Personal Laws comprised of 190 articles and 5 books. The code covers personal status, marriage and divorce, matrimonial and family relations, succession and inheritance, and property relations between spouses. Next. The application, the decree to ordain and promulgate a code recognizing the system of Filipino Muslims laws, codifying Muslim personal laws, and providing for its administration and for other purposes. Article 1, the title, this decree shall be known as the Code of Muslim Personal Laws of the Philippines. Article 2, purpose of code, pursuant to the Section 11 of Article 15 of the Constitution of the Philippines, which provides that the state shall consider the customs, traditions, beliefs, and interests of national cultural communities in the formulation and implementation of state's policies. This code recognizes the legal system of the Muslims in the Philippines as part of the law of the land and seeks to make Islamic institutions more effective, codifies Muslim personal laws, and provides for an effective administration and enforcement of Muslim personal laws among Muslims. The code does not cover the entirety of Sharia, only elements of personal laws, and does not recognize Sharia as separate autonomous system of law. It is rather a part of the wider justice system of the state. So sinama ko lang po dito yung sa Article 10, modes of succession. Succession may be by will, wasiya, by operation of this code, or by combination of both. And Article 7, bequest by operation of law. Should the testator die without having made a bequest in favor of any child of his son who predeceased him or who simultaneously dies with him, such child shall be entitled to one-third the share that would have pertained to the father if he were alive. The parent or spouse who is otherwise disqualified to inherit in view of Article 93-C shall be entitled to one-third of what he or she would have received without such qualification. So next slide. It highlights understanding why the shares of men is much more than women and the reason behind it, and also the precise sharing or location of shares to each person who are entitled to it. Very important points from this Ayah 11 and other Ayah of Surah Al-Nisa. We receive a lot of knowledge from our Quran, Sunnah, and Ijma. The Prophet Muhammad, peace be upon him, said, "Give the fara'id to those who are entitled to receive, and whatever is left is for the closest relative." So sa point na to parang ma-observe mo talaga kung gaano mo ka lamang lalaki in terms of hatian. Kasi nga sa mga responsibility na meron ng lalaki. And it is very important for us to learn and know this knowledge for it benefit us all and also an obligation for everyone that must be applied. So yun ang po sir.
Okay. Thank you very much no for your report at medyo yung iba mga advanced na topics no. So alhamdulillah so kindly upload all of your PowerPoint presentation doon sa ating natin sa ating Google Drive na sinubmit. So if you have any question doon sa report ni Yasin no ano niyo lang sulat nyo lang dun sa chat box. Okay, so ano mo, Sheikh, landscape para mas lumaki. Rotate mo yung screen. Ayan.
Assalamualaikum warahmatullahi wabarakatuh. Naririnig po ako.
Loud and clear.
Loud
Malinaw.
and clear. Bismillahirrahmanirrahim. 4 verses of the Surah An-Nisa talk about the legal provision for women on the right of inheritance. This being verses of the Surah An-Nisa, number 4 and 7, 11 and 12, and 176 ayah in the Quran. tayo ay magfo-focus sa policies of how the woman will inherit deceased person's property. We talk about source share system lies in two verses of the Quran in Surah An-Nisa. Allah subhanahu wa ta'ala say, Yusikum Allahi fi awladikum. Allah direct you as regards your children's inheritance. للذكر مثل حظ الأنثيين. A son's share is equal to the share of two daughters. فإن كن نساء فوق اثنتين ثلث ما ترك. If children are only daughters and two or more, their share is 2/3 of the inheritance. وإن كانت واحدة فلها النصف. And if there is only daughter, her share is half of the inheritance. For the parents, Allah subhanahu wa ta'ala say, وَلِأَبَوَيْهِ لِكُلِّ وَاحِدٍ مِّنْهُمَا السُّدُسُ مِمَّا تَرَكَ إِنْ كَانَ لَهُ وَلَدٌ. For parents, a 1/6 share of the inheritance to each if the deceased leave children. فإن لم يكن له ولد وورثه أبواه فلأمه الثلث. If no children and the parents are the only heirs, the mother has a third. فإن كان له إخوة فلأمه السدس. If the deceased leave brother or sister, the mother has a 1/6. من بعد وصية يوصي بها أو دين. The distribution in all cases is after the payment of legacies and debit. So the question, why have women discriminated against with allotment of the share of men? Do women have an unfair share in inheritance? That is a question. This is controversial rule is that female share is half the male, except for the cases of the mother's yung matatanggap ng magulang na inheritance ay equal sa father. In order to understand the reason behind the rule, one of the take into account the fact that all the expenses of wives and children must be paid by husband or father, whereas women are not required to work and pay for such living expenses. At isa pang reason, man responsible for the welfare of his parents and female member of his family for as long as they remain unmarried. If a woman has a wealth, pag may kayamanan o ari-arian yung babae, she is not required to spend it for her family. At isa rin sa reason, men have to bestow mahar upon their wife. Tatandaan natin dito na ang mga kababaihan ay matatanggap nila mula sa kanilang mga asawa ay buo na mahar. Islam does not deprive any inheritor of their legal right to property of the deceased. Meron ditong different of ratio between man and the female. As the clarity of the distribution of the property, Allah subhanahu wa ta'ala say in the Quran, in the Surah An-Nisa, verse 12, وَلَكُمْ نِصْفُ مَا تَرَكْ أَزْوَاجُكُمْ إِن لَّمْ يَكُن لَّهُنَّ وَلَدٌ. In what your wife leave, your share is half if they leave no child. فَإِن كَانَ لَهُنَّ وَلَدٌ فَلَكُمُ الرُّبُعُ مِمَّا تَرَكْنَ. But if they leave a child, you get a fourth. مِن بَعْدِ وَصِيَّةٍ يُوصِينَ بِهَا أَوْ دَيْنٍ. After payment of legacies and debit. وَلَهُنَّ الرُّبُعُ مِمَّا تَرَكْتُمْ إِن لَّمْ يَكُن لَّكُمْ وَلَدٌ. In what you leave, their share is a fourth if you leave no child. فَإِن كَانَ لَكُمْ وَلَدٌ فَلَهُنَّ فإن كان لكم ولد فله الثمن مما تركتم. But if you leave a child, they get an eighth من بعد وصية توصون بها أو دين after payment of legacies and debit. وإن كان رجل يورث كلالة أو امرأة وله أخ أو أخت فلكل واحد منهما السدس. If the man or woman whose inheritance in the question has left neither ascendants or descendants, but has left a brother or sister, each one of the two get 6. فإن كانوا أكثر من ذلك فهم شركاء في الثلث. But if more than 2, they share in a third. من بعد وصية يوصى بها أو دين غير مضار. After payment of legacies and debit, so that no loss in cause to anyone. This is the table na makikita natin sa na nabanggit natin kanina. A brief history of the Philippine Code of Muslim Personal Law and Application. Code of Muslim Personal Law of the Philippines is among the many codes and ratified during the Marcos era. In 1973, former President Marcos headed Senator Tamano call when he issued memorandum order in August 1973, said in that memo created a research staff or research group to draft the proposed code of the Philippine Muslim law. A year later, executive order designated Cesar Mahul of the IS275 to lead the Presidential Commission in reviewing the draft code. The Presidential Commission had 11 members. The Dean of the IISUP, representative from the Supreme Court, the Integrated Bar of the Philippines, DOJ, and the UP Law Center, the Catholic Hierarchy, the project officer of the research team formed by the MO 370, the 2 Muslim lawyer, and the ulama religious leader. President Marcos received the group final report and draft code in 1975, and naging batas na sa ibatas na ito, become a law in 1977. Marcos signed President Decree PD 1083. So, bakit, may katanungan dito, bakit sa pagkapasa ng Decree PD 1083, hindi ito kaagad na implementa? Dahil dito, the Office of Muslim Affairs in post-Marcos era, established in 1982, ngayon ang Philippine Sharia Institute, nag-provide sila ng Sharia legal education para sa prospective Sharia bar examinees, law practitioner, and judges. After a year, the first special bar examination for the Sharia court was conducted at Sham. 9 successful candidates were appointed as Sharia judges. It was only in 1985 when Sharia court opened. The Code of Muslim Personnel of the Philippines became operational 8 years after its after netong naipasa. So, naging law, PD 1083. In additional, the constitutional basis called found in Article 15, Section 2 of the 1973 Constitution. Ganun din matatagpuan din dito sa Article 2, Section 22 of the 1987 Constitution. So, ano yung pinaka-goal ng codification ng PD 1083 with the constitutional basis are the following. Unang-una sa lahat, para ma-recognize ang legal system nating mga Muslim dito sa Pilipinas. Pangalawa, para ma-codified Muslim personal law. At pangatlo, effective administration and enforcement of Muslim personal law. Sumunod naman, the source and significance of the law on succession in Islam. Let us learn the basis sources of the law on succession. First, Allah subhanahu wa ta'ala say in the Quran as our basis, ثم جعلناك على شريعة من الأمر فاتبعها ولا تتبع أهواء الذين لا يعلمون. Then we give you a sharia in a religion, so follow it and do not follow the laws of those who do not know. So what are the sources of the succession under the Islamic law? We explain each briefly. The following are the Holy Quran, Hadith, Ijma' al-ulama, custom or usage. Quran, the shares of the legal heirs was fixed in the revealed books, especially the shares. And second, the Hadith, this refers to the saying of the Prophet Muhammad with regard to inheritance. For example, is saying of Prophet Muhammad na sinabi niya, no will and heir. Sa ijma' al-ulama naman sa ikatlo, this refer to the consensus of the jurists when there is no applicable rule expressed in the foreign sources. Pang-apat, yung custom or usage. This refers to the way accustomed by the people in distributing the inheritance to the heir in their shares. At dito na lamang nagtatapos ang aking pag-report. Assalamualaikum warahmatullahi ta'ala wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Syukran jazilan. No? Maganda at informative na report. Okay, so sinong susunod? Kasi yung time natin, no? Si Bakri, ha? O yun, mayroon pa si Ma'am Nabila. So sino mauna sa inyo?
أنا جاهز شيخ.
Aywa, tafadhal. So si Muhammad Bakri muna.
Malinaw شيخ, nakikita po?
Naam. Tafadhal.
أعوذ بالله من الشيطان الرجيم. بسم الله الرحمن الرحيم. الحمد لله رب العالمين والصلاة والسلام على نبينا محمد وعلى آله وصحبه أجمعين. أما بعد. السلام عليكم ورحمة الله وبركاته. Unang-una sa lahat, paumanhin po dahil yung format po hindi po nasunod yung gusto niyo po check. Inshallah sa susunod po na presentation masusunod na po inshallah. So firstly, the share of women under Islamic law on inheritance. So kinuha ko itong, I took this text, yung matan na ito sa matan ar-Wahbiyya fil Fara'id. Sabi dito, what said here, that al-warithatu minan nisa'i sab'u lam yu'ti untha ghayrahunna ash-shar'u bintun wa bintu banin wa ummin mushtaqa wa zawjatun wa jaddatun wa mu'taqa wal ukhtu min ayyi al-jihati kanat fa hadhihi 'iddatuhunna banat. Sabi dito, it's explained here that there are only 7 females who are entitled for inheritance. And the inheritance from the woman are 7, no other female given by the law except them. Daughter, son's daughter, a fearful mother, wife, grandmother, freed slave, freed female slave. A mu'tiqa is not a female, is a master of the female. It's a female master of freed slave. And sister from any side, these are their clear numbers. So we'll continue. These are the situations, share of surviving wife. ولهن ربع مما تركتم إن لم يكن لكم ولد فإن كان لكم ولد فلهن الثمن مما تركتم. In absence of descendants, the wife will inherit 1/4. With legitimate child, the wife will inherit 1/8 of the property after wasiya and dayn, of course. And the second is the surviving daughter. After the wife is the surviving daughter. يوصيكم الله في أولادكم للذكر مثل حظ الأنثيين فإن كن نساء فوق اثنتين فلهن ثلث ما ترك فإن كانت واحدة فلها النصف. The situation is, if there's an only daughter without son, okay, she will take 1/2 of the property. In the situation of 2 or more daughters, they will take 2/3 of the property. They will inherit 2/3 of the property. And in the situation that 1 or more daughters with 1 or more sons, so the principle will apply. للذكر مثل حظ الأنثيين, 1 male is equivalent to 2 female. And the third situation, the third woman will take the share is son's daughter. In absence of any child of this descendant, she will take 1/2. If the situation is 2 or more daughters of descendant's son, she will take 2/3 of the inheritance. And the fourth is the full sister. In full sister, it is mentioned that إن امرؤ هلك ليس له ولد وله أخت فلهن نصف ما ترك وله أخت ولا عفوا إن امرؤ هلك ليس له ولد وله أخت فلها نصف ما ترك وهو يرثها إن لم يكن لها ولد فإن كانت اثنتين فلهما الثلثان مما ترك. So the situation here is, in the absence of descendant, father, full brother, grandfather, and son, she will take 1/2 of the inheritance. So when she had 2 or more full sisters, she will take 2/3 of the inheritance. Also, the consanguine and uterine sisters also have their shares of inheritance. So after that is the share of surviving mother. The situation is the share together with child of descendant's son, or 2 more brothers or sisters of descendants, she will take 1/6 of the property. In absence of the mentioned title, she will take 1/3 of the property. The share of surviving mother, share of surviving grandmother. So succeeding in default of mother, in the absence of mother or father of the deceased, the grandmother will take 1/6 of the property. Of course, there's a hadith also about Umar bin Khattab radiallahu anhu, what he decided for the grandmother. We will talk about it later, inshallah, after maybe on the next 2 or more pages. Inheritance of lady master from freed slave. I think this is not mentioned in PD 1083 because we don't have this situation in the Philippines, having slave and freed slave and all of that. So the book of fiqh, some books they mention also this situation. In case the freed slave died and doesn't have direct inheritor, the lady master who freed the slave will inherit the total wealth after payment of debt and implementing the will wasiyah. After that, she will inherit all the wealth. This is the hadith which I have some question about it also. A grandmother came to Abu Bakr Siddiq radiallahu anhu, asked him for inheritance. Abu Bakr said to her, "You have nothing in the book of Allah, and I do not know you have anything in the Sunnah of Rasulullah sallallahu alaihi wasallam. Go away, therefore I will go away until I have question the people. He is talking about the Sahaba radiallahu anhum. So he questioned the people, and Al-Mughira ibn Shu'bah said, I was present with the Messenger of Allah sallallahu alayhi wasallam when he gave the mother, or he gave a grandmother 1/6. Abu Bakr Siddiq radiallahu anhu was there. Any else? He asked Al-Mughira, was there any else with you? Muhammad bin Maslama al-Ansari stood up and said the like of what Al-Mughira said. Abu Bakr Siddiq gave it to her. So Abu Bakr Siddiq gave the 1/6 to the grandmother. So yung hatol nang gagaling dito na ang grandmother will take 1/6 of the property in the absence of mother or father of the deceased. So same situation came to Umar bin Khattab radiallahu anhu, and Umar bin Khattab said, you have nothing in the book of Allah, and what has been decided is only for other than you, and I am not one to add to the fixed shares. Other than that, 6. If there are 2 of you together, it is between you. If either of you is left alone with it, it is hers. So my question here is the judgment of Umar ibn al-Khattab radiallahu anhu, that he said, وَمَا أَنَا بِزَائِدٍ فِي الْفَرَائِضِ شَيْئًا وَلَكِنَّهُ ذَلِكَ الثُّلُثُ فَإِنِ اجْتَمَعْتُمَا فَهُوَ بَيْنَكُمَا وَأَيَّتُكُمَا أَخَلَّتْ بِهِ فَهُوَ لَهَا. So what's the judgment of Umar radiallahu anhu in its early period can be called an analogy, qiyas. And if it's an analogy, a qiyas, from what source he derived the analogy? So inshallah, later I hope Sheikh can answer this, because some scholars that they speak about it, and they thought that the hukum of Umar radiallahu anhu became ijma sukuti. I don't know if how true is that. So
Yeah.
Sheikh will explain to us.
Yes, actually, that's the case for true grandmother. So true grandmother, when we say true grandmother, this is the mother of the mother, then the mother of the father. So these
Yes.
are true grandmothers. So wain ala, no, kahit gaano pa kalayo. So mother's mother's mother, then yung father's mother's mother. So ganon. So yun ang mga true grandmother, and they will share sa 1/6. And as you have said, this is an ijma. Ang basihan niya yung hadith, no, kasi yung after magtanong si Abu Bakar, no, nung hanapin niya yung ano. So that's basically hadith, what Al-Mughira bin Shu'bah and Muhammad bin Maslama al-Ansari have said. This is from the Prophet Muhammad sallallahu alaihi wasallam. So yun ang dalil din ni Umar bin al-Khattab. So kasi ang sinabi is grandmother. So Jad.
So it's
so minimin doon ay Jad. Hindi, ang minimin doon na grandmother yung true grandmother lang.
Okay.
Yung Jadda as-sahiha.
In both sides.
Both side, mother's mother or father's mother.
Barakallahu fik, Sheikh. Shall I continue?
Siya, proceed.
Sources and significance of the law of succession in Islam. First source is we have the Quran, the words of Allah subhanahu wa ta'ala revealed to Prophet Muhammad sallallahu alayhi wa sallam, miraculous in its sound and meanings. Its recitation is an act of worship conveyed to us successively by numerous narrators. The first chapter of Quran is Surah Al-Fatiha, and the last chapter is Surah An-Nas. And second is Hadith. The second source of the law is Hadith. It was narrated about the Prophet Muhammad. What was narrated about the Prophet Muhammad sallallahu alaihi wasallam in regards to his actions, words, action approved, and his attributes. Sallallahu alaihi wasallam. The third is Ijma', consensus of the Islamic scholars after the death of Prophet Muhammad sallallahu alaihi wasallam in certain period of time for Islamic ruling. So there are two types of Ijma'. It's Ijma' Sarih. Ijma' Sarih, this the scholar agreed upon all of them in the same rulings.
Explicit.
Yes. And the second is Ijma' Sukuti, which some of the scholar or one of the scholar decide on a ruling, and everybody was silent and nobody speak against him or against that ruling. And القياس is the process of deductive in which the teachings of hadith are compared and contrasted with those of the Quran in order to apply a new injunction, a new law. The question, Sheikh, is when does the qiyas of mujtahid become ijma' or sukuti? What there's a certain period of time that, for example, after 3 years, after 10 years, this ijtihad of a scholar become ijma' sukuti or something like that. And what was the level of authenticity of hadith to be taken as a law on inheritance? Is ضعيف جدا or ضعيف can be taken as a law, or because some scholars speak that the hadith ضعيف can be taken as a law of haram and halal, marriages
Yes.
and other things.
Okay. Siguro let's briefly discuss this. No? So, Qiyas, no? Qiyas can only be an ijma if there happened, no, in one generation. So if, for example, in a generation, in an era, there exists a number of mujtahid, then a particular mas'ala, for example, an issue was given a ruling by a mujtahid after, of course, exerting his efforts. No? Then if, it may be by way of qiyas, by way of istihsan or istislah, or any of the tools available for a mujtahid. So if it is by way of qiyas, then after this ruling of a mujtahid was made known to all of the mujtahid alive in his generation, in his era. So, and there's no one who contradicted him, then some scholars consider this as an ijma, and it is called ijma sukuti, or what they call implicit ijma. But take note that majority of the scholars only accept ijma sahaba, because after the era of the Sahaba, the companions, they said that the people were dispersed to many places, and it is impossible. It is near impossible to have an ijma. So we don't know. So maybe a mujtahid existing in that era or generation did not hear about that mas'ala. So it will not count as he implicitly agreed with it. So that's why some scholars don't accept ijma as sukuti as strong as the ijma of sahaba. But when it comes to the ijma of sahaba, there's an ijma, no? There's a consensus. Everyone accepts that if it's an ijma from the sahaba, it is as if, no, it is as if it's the third, no, it's the third source of law. Ganong kalakas ang ijma of sahaba. So ganon ang nangyari. Then what was the level of authenticity of hadith? So ang tatanggapin lang na grade para sa mga ahkam, mga rulings ay hasan, no? Daif, no? Tsaka daif jiddan ay hindi yan tinatanggap when it comes to rulings. Tatanggapin lang sila sa targhib wa tarhib, sa mga as a support, no, maybe, but it will not create a ruling, no, by itself, itong mga daif and daif jiddan. So kung ito ay hasan and sahih, yan ang pwedeng yan ay tinatanggap as a source, no, as a basis for a ruling. Please proceed.
الشيخ إجماع ابن المنذر إجماع ابن حزم معتمد شيخ؟
الله أعلم. ابن حزم معروف أنه يعني عنده أقوال. So ang kay
مخالف
Ibn
العلماء.
Hazm naman no? Medyo leaning din kasi siya din sa Zahiriya, etc.
Mm.
So, gaya ng sabi natin, no? Ang ijma, after the ijma of the Sahaba companions, it is very hard. It is very hard to prove that, because as they have said, the scholars have said, how can you be certain that all of the mujtahid have heard that issue, and also the fatwa or the ijtihad of a particular mujtahid, and they did not disagree with it, or they have impliedly agreed with it? You cannot be sure of that. So, ang madali lang talagang ma-prove ay yung ijma ng mga sahaba. Dahil
No.
maliit sila at nasa isang lugar, madali lang, no? So, after the sahaba, mahirap. But it doesn't mean that ijma sukuti and other
Mm.
forms of ijma is not it doesn't have any weight. Meron, no? It does have weight, no? Kasi gaya na sabi natin, it becomes kasama na yun sa mga secondary sources, no? Ang talagang primary, yung pag sinabi natin after the Quran and Sunnah, kapag ito ay naging ijma, particularly ijma ng mga sahaba, mas mabigat siya, no? At as we have said, if a ijma has been constituted, it cannot be repealed by another ijma or another opinion after their generation. So for example, ang mga sahaba nagkaroon ng ijma, ang mga tabi'in, those who come after the sahaba cannot uh, go against the ruling where there is a consensus amongst the Sahaba. Please continue.
شيخ إجماع الصحابة in particular or إجماع القرون الثلاثة؟
Ijma of the Sahaba, particularly yan ang hindi talaga na ano. At yung mga ijma sukuti, gaya ng sabi nga natin, hindi siya ma-prove, no? Na talagang nagkaroon ng ijma. So sometimes, lalo na pagbasehan niya ay sinasabi, there's an ijma sukuti, no? Kung sabi nila, or there may be an ijma. So kung ito ay basehan niya ay mga custom, yung mga orf, wal-ada at iba pa, some scholars, no, said na hindi talaga kino-consider yun as yung uri ng ijma na hindi nare-repeal.
جزاك الله خير شيخ. So I'll continue with the PD 1083 history and application. Muslim delegates during the Constitutional Convention of 1971 sowed seeds for the formulation and eventual ratification of Code of Muslim Personal Laws. They influence government policies through a provision that recognizes national cultural communities and their corresponding customs and beliefs. In February 1973, former Senator Mamintal Tamano supplemented the delegates' effort when he gave a memorandum exhorting the President Ferdinand Marcos to issue a decree recognizing Muslim personal laws. President Marcos heeded Senator Tamano's call when he issued memorandum. In August 1973, that memorandum in August 1973, said memo created a research staff to draft the proposed Code of Philippine Muslim Laws a year later. Executive Order EO 442 designed Cesar Mahul of the Institute of Islamic Studies of the University of the Philippines to lead the Presidential Commission in reviewing the draft code. On February 4, 1977, Presidential Decree 1083 was signed into law. This decree shall be known as the Code of Muslim Personal Laws of the Philippines, provides for an effective administration and enforcement of Muslim personal laws among Muslims. Jurisdiction of the law is limited only to the Muslim personal and family issues like marriage, divorce, and inheritance. So hanggang dito lang siya. Jazakumullahu khairan, barakallahu fikum.
Fecal baraka. So, sino ang susunod na si Ma'am Nabila? Tafadhali.
Yes po. Okay, so Assalamualaikum everyone. Um, these these are the three questions that I personally picked for the given topics. So this is the shares of women, but since this has been discussed earlier, for lack of material time, I will not go into details na. So let's go to the question of why is the share of one woman equal to the share of two women? So it has been the subject of inquiry why the share of a woman is half of the share of a man. The answer is the Islamic Sharia differentiates the two in inheritance because of several reasons. And some of them are the expenses and the support of a woman are well taken care of by either the son, her father, a brother, or any one of her relatives. And the woman is not obliged to support anyone, unlike a man who is obliged to support his family and relatives. The expenses of a man transcends those of a woman. The man is obliged to give a dower to his wife, the family home, and provide food and clothing, and the man has to support his children in their schooling. So he has to prepare for the medication, hospitalization of his wife and children when the need arises. So these duties are not required of a woman. So next is the basic sources of the law on inheritance. So it is the Holy Quran, Hadith, Ijma al-Ummah, custom or usage. But the present code of PD 1083 has for its sources, in addition, the Civil Code of the Philippines and the Filipino Muslim customs. So these are actually the significance or five main considerations of the law of inheritance. So the Code of Muslim Personal Laws of the Philippines. In legal sense, personal laws are those which pertains to person. It is that which follows the person as distinguished from the place where the person may be. So the Code of Muslim Personal Laws of the Philippines is a body of laws that treats the personal laws of a Muslim in the Philippines and provides for the administrative machinery for its implementation. So it applies only to Muslims in matters relating to their personal status, matrimonial and family relations, succession and inheritance, and property relations between spouses. But non-Muslims are not embraced in the law, except in those cases provided by the code. So next is as to the historical background. So the present code of Muslim personal laws of the Philippines is the result of the Islamic influence that was first introduced in Sulu by the early Muslim missionaries. The period is believed to be about 710 after Hijrah on the basis of the inscriptions in Arabic alphabet found in the tomb of Juan Magbalo at a place some kilometers from Hulu. So um, there are actually practices before that the Sultan and the Raja were the protectors and upholders of the Islamic law or the Muslim law. So in order to guide the Qadi or mga Qadis, the sultans tried to codify some selective aspects of personal laws. Consequently, on February 4, 1977, PD 1083 was signed into law, thereby finally giving reality to the aspiration of the Filipino Muslims to have their system of personal laws recognized, enforced, and applied to them. So as highlights, I have two highlights here. So the first is the expenses and support of a woman are well taken care of by either her son, her father, her brother, or any one of her relatives. So share ko lang as personal reflection. I would say some men in our communities nowadays seem to forget their simple duties. So um, actually, when I was a teenager, my aunt, the first cousin of my father, she is a single mother with 3 young children. So she was in a difficult time that and shared to me her struggle. So she vented out on me. At that time, she has no job or income, and she really don't have any money. She was neglected, or some of her male relatives are not giving her financial support, knowing she is raising her 3 kids alone. So she was actually crying, and she told me it should be the obligation of her male relatives to support her. So, well, this could be a simple reminder, maybe, that men should also check on their female relatives, especially those who are not financially stable. Otherwise, the rationale on why the share of men is twice that of the woman will be useless. So yun, another highlight, the code did not codify all the elements of Islamic law that applies to personal and family law, and it still allows the adoption of other Muslim personal laws, which are not included in the code. So the code is not exclusive in details regarding Muslim personal law. So we still can resort to other Muslim laws outside the Philippines with the help of our ulamas or someone more knowledgeable in Islam. So as a closing VIP, to the male, a portion equal to that of 2 females. This has actually been a controversial ayah that seems unfair, but this is justified in the sense that beyond those words and apparent unfairness, there are duties and obligations shouldered by men in favor of their female relatives, and there is privilege naman for women. So ayan po, that concludes my report po. Thank you.
Thank you very much. Shukran jazilan wa jazakumullahu khaira. So don't forget to upload all of your presentation materials doon sa Google Drive link that I have posted in our group chat. So any questions or clarifications? May tanong ba tayo doon sa mga kaninang discuss? We will go further in details regarding the shares, no? So dito sa Ashabul Furub, Ashabul Mirat, or yung Asaba. Earlier, dun sa mga, may namapansin tayo, no? Na medyo, pwede pang dagdagan, no? Yung, may mga, and then may mga special cases at the same time na hindi naman natakal dun sa mga report. But that's not our topic for today, no? Kasi introduction pa lang naman tayo. Then later we will have all the details regarding the shares of all ashabul furud, yung mga may fixed shares, and also yung mga ashabul mirat, yung mga asaba, malalaman natin, and we will also have some computation how to compute properly yung mga shares. So, kung any other question, wala na ba? Klaro na ba lahat?
Siya yung regarding sa ano po. So, laging nababanggit kasi yung tradition or yung ada kanina. So, it's considered as law. Kasi sa Malikiya, Amal Ahl Madina, kasama sa ano nila. Pero tayo ba, considered ba sa atin na as law yung ada? Kasi kung abrogated naman ng Quran at saka Hadith, bakit pa kailangan natin ng ada?
هناك قاعدة فقهية العادة محكمة. So ang ada ay shall have the weight of law. So in any time or place, as long as this ada is considered as the shurut, no? As all the shurut, the conditions for a valid ada or orf, it shall have the weight of law. So why is it being recognized by Islam, no, or the Sharia as part of Islam, as part of its Sharia? Because Sharia or Islam did not came to erase all the customs. Hindi yan ng no. So it might have, of course, certainly, Islam corrected some practices, some customs and usages that were against Islam. So all of those customs and usages, this orf and ada, that are against Islam, against a particular verse or hadith of the Prophet Muhammad sallallahu alaihi wasallam, these are all abandoned. This will not have the weight of law. This shall not have any legal effect. So yun ang pinaka main condition for an ada to be accepted is it should not go against the Islam and against Quran and Sunnah. So saan ba nagagamit? So ang orf and ada ang pinaka siguro practical na application niya is that it complements the laws, the rulings in the Quran and Sunnah, and sometimes it give details to the rulings o mga ahkam, no, sa Quran at Sunnah. So let's give an example, no. So an ayah in the Quran, it says wa'ashiruhunna bil ma'ruf. So and live with your wives, with your family, with your wives bil ma'ruf. So by what is good. So ano ba tong good na to, no? It did not give any details, no? The Quran did not give any details. The hadith also did not give specific details. So ang babalik yan sa ada, sa custom ng isang community. So if a community na ang kinukonsider nila ang living with your wife or yung having yung kinukonsider na papasa doon sa sinabing good pakikitungo sa asawa ay ang pagbigyan siya ng bahay, no, sariling bahay, at may mga katulong sa bahay, kasambahay, doon mo ma-achieve yung obligado sa iyo na muasyara, yung wa'ashiruhunna bil ma'ruf. Doon mo palang ma-achieve yon. So bumabalik yan sa ada, sa custom. Pero kung hindi naman ang sapat lang is as long as may ang nakagawian, kino-consider na sa community nyo na magandang pakikitungo sa asawa, ay may masisilungan, ma-provide ka ng pagkain, hindi naman required na magkaroon ng mga katulong, bahay, sasakyan, etc. So hindi ito ang required sa iyo. So ang ada, no, al-urf wal ada, no, gaya nga ng kaida, nakalimutan ko lang yung lafz, no, in its nearest meaning, yung sabi nga sa kaida, al-urf wal ada, ang urf at saka ada ay nagbibigay ng nagbibigay ng details and limits doon sa mga hindi binigyan ng details and limit ng Quran at saka ng Sunnah. So yan ang function ng ada at saka ng orf, no? Al-orf wal ada, ito yung customs and usages. Hopefully klaro yan.
Sa mirath, Sheikh, meron nangyayaring ganyan po
sa mirath, dahil sa atin ngayon, no, ang mini-mention doon na custom and usages, that was the custom before, no, and usages. So katulad ng sinasabi natin na ang pinakamalaking example, always the male has a preferable share. So ito ay pinanggalingan basehan nito ay custom, no? So but it was adopted. It was made part of the law of part of Sharia. So ano pa rin yan, existing pa rin yon, no, yung preference, male preference share ng inheritance. So ito ay ang pinanggalingan daw niyan ay ada. At gaya ng qiyas and other tools of and other sources of law, kapag ito ay naging katulad ang ada, no, kapag ito ay naging ijma, no, lalo na ijma ng mga sahaba, nagiging part to ng Sharia.
Hindi siya mukaddam sa qiyas, Sheikh.
Ang ada?
No.
Ang ada kasi nakadepende yan sa lugar. Hindi pare-parehas ang ada ng Saudi, ng Pilipinas. So hindi yan So ang applicable na ada sa Saudi, hindi mo pwedeng dalhin na sabi mo applicable din dito sa Pilipinas. That's why some are mistaken, no? Na kung anong ruling na nandoon sa sinabi sa fatwa ng ating mga
Copy-paste na.
kapitapitagang mga ulama sa mga kibarul ulama sa Saudi ay dapat applicable na daw dito sa Pilipinas. No. No, kasi ang fatwa ay nakadepende yan sa lugar, sa oras at saka sa tao. Hindi lahat ng fatwa ng ating mga kibarul ulama, no, hafidhahumullah, ay applicable sa atin sa Pilipinas. So, always kinukonsider pa rin yung custom and usages natin, yung ADA or full ADA natin dito sa Pilipinas. Okay, other questions or clarification?
Sir, just to add, yung ang applicable law for us Muslim, the primary sources will always be the Holy Quran and the Sunnah, and ADA will only apply suppletorily, will only supplement. Yun po. Parang minsan po, parang may mga naririnig ako, parang dinidiscuss much on the ADA and the other, but may mga different applications. So like in some cases which I read, so supplementary lang, sinusupplement lang kung ano yung kulang. Remember, still the law that will apply is the law that is provided by our Holy Quran and the Sunnah of the Prophet.
Yes.
Additional po lang po, sir.
Yes. Particularly, actually, very important ang ADA, ang cost, lalo na sa mga contracts. So if there's an contract, no, kontrata, for example, no, ganon din, no, kunyari nagkaroon ng kasal, yung mahar hindi na specify or hindi maalala, no, ano ba yung mahar na pagkasunduan or hindi na specify. So babalik ito sa ADA, no? Ang magde-decide niyan ay ang ADA. So kung ang kunyari sila magkakapatid, ang nakasanayan na ADA sa kanilang magkakapatid o ang nakasanayan na mahar sa kanilang magkakapatid na babae ay ganitong amount, dahil nakalimutan or hindi na mention ang mahar, ang kukunin ay yung mahar na katulad doon sa nakasanayan. So ito ay mahar mithl, no? So yun ang sinasabi natin na very important ang ADA. So kung nagkaroon din ng kontrata at sinabi ito ay binenta ko na sa itong lupa ng 500,000. So hindi minention kung ito ba ay pesos, ito ba ay dollar o ano. So ang babalik ka doon sa lugar na yon. Kung ano yung nakasanayan na pera, yun ang magiging applicable. So ang ADA, palagi yan binabalikan, no? Al-ADA to muhakkama. The ADA shall have the weight of law. Palagi itong titingnan kasi hindi naman ng ano yan eh. So very particular din lalo na sa mga kontrata. So yun ang ano natin. Any questions? Wala na bang may dadagdag? So inshallah we will proceed or we will continue with our discussion next meeting. And let me just share yung ano nyo, magiging assignment and also yung report nyo. So, wag nyong kakalimutan, no? Dito, ang nakapag-submit lang 5. Dito naman ay 6. So ito yung for today. No? So, mag-write ulit kayo ng review of understanding nyo. This will help you, no? To consolidate what you have learned, what you have taken down. Yung notes, mga na-jot down nyo. Then, ang next topic natin ay yung mga definition of terms and abbreviations, successional rights, vested causes of succession, essential elements of succession, essential requisites of succession, causes of succession. Naulit lang, no? Tanggalin lang. Disqualification to succession with the views of 4 Sunni madhahib. So yan ang magiging topic. Diyan kayo kukuha ng inyong report. Then please, no, magandang i-implement na yung yung 3-2-1 natin na approach para mas maikli, malimit niyo yung oras nyo at the same time yung sa tingin yung pinaka-importante, no, ay yun ang ma-discuss nyo. Kasi magkakaiba ang magiging reflection, no? At saka parang realization ng bawat isa. So at least kung may ano tayo, mas magiging effective and efficient ang ating reporting. Kung wala nang tanong, no, we will continue next meeting and continue sa pagbabasa. Kung may tanong naman, maisip kayo mamaya, you can ask it in our GC. Marami pwede nating i-discuss together. Okay? So alhamdulillah. So we're done for today. نكتفي بهذا القدر اليسير. فإن شاء الله نلتقي في الأسبوع القادم. في أمان الله. مع السلامة. إلى اللقاء في أمان الله. فالسلام عليكم ورحمة الله وبركاته. كفارة المجلس.
وعليكم السلام
وعليكم
ورحمة الله
السلام.
وبركاته.
Alhamdulillah.
Alaikum salam.
نشهد أن لا إله إلا أنت نستغفرك ونتوب إليك.